Okay. You
All right,
can mute me whenever you want, Jake and Ellen.
fair enough. And you'll make us do timeout. All right, so people are starting to populate in. Wow, we're getting some. It's like Taylor Swift concert. Everyone's rushing through the door.
Inside Edition and Extra both showed Travis's plane landing in Australia or wherever she is.
Actually,
Sydney.
this is very topical for our discussion today. They also showed them at the Australia Zoo, and they're getting backlash because they let you actually interact with the pets at the zoo or animals at the zoo. And that's apparently PETA's getting all up in arms about it. They said they should go to a one that you're not allowed to interact with the animals. So
Of course, as a reasonably prudent lawyer, I would say to the zoo, what's the liability issue that you're getting into here, folks, when you start petting the lions and tigers? Oh my.
well, it's Australia, so
I
it's
know.
probably
Yeah, they're not worried about
Probably
yeah.
upside down it. And my last comment for the hour is in
For the
Australia, when you flush the toilet, does it go the other way from toilets up here? The water?
I was there for a couple months, so I didn't really
You didn't
observe
pay
that.
attention.
Yeah, no.
Okay.
He was the bathroom when he was there. They weren't clean enough. He waited till he came
I
home.
was avoiding all the crazy animals, kangaroos and all that. So
Okay. Jake, do you want to start and maybe say something about New England?
yeah, I was just about to do that. So yeah, so we thanks everyone for coming today. This is our 12th episode of the Marcus Hour.
Happy anniversary.
Happy anniversary, 1 year, and we have a very special guest or
We have a bunch of special guests.
This will be a good one today. It's an exciting topic. And yeah, we've been doing these for a year now, and all that we try to hit on the hot topics that are covering the condo world. We are Alcock and Marcus. Today we have 3 members from Alcock and Marcus, full service law firm representing, you can see it here, Massachusetts, Rhode Island, New Hampshire, Maine, and Florida. And we've been up and running for 18 months. And this is part of our educational services. This is not to be legal advice. If you need proper legal advice or specific questions as it relates to your situation involving pets, involving what have you, we are a full service firm. We are happy to help or consult with an attorney to ensure that you get the proper advice. But this is for educational services. Today is a fun one. We are discussing, and I'll get the slideshow started. Oops, yeah, there we go. Oh, wait, hold on, I have to do share screen. Yeah, you can't tell we've been doing this for a year. I still don't know how to share the screen. So here we go. So those are our mug shots. We got my dad, Stephen Marcus, on the left-hand corner. That's me, Jake, and then Ellen, our guest speaker, the expert on FHFA requirements, and she will be a wealth of knowledge today for us. And then we also have a couple other special guests. This is James. He's a dog, and this is Digby.
And he's a dog.
And he's a dog. He's 13 years old, Pekingese pug. And James is an 8-year-old Pekingese poodle, and they're both wearing their best outfits today. I do want to give a quick shout out to Community Associations Institute, mainly Community Associations Institute New England. We work heavily with them. We also work with Community Association, CAI, Southeast Florida, and CAI National. We are actually, Stephen and I were just at the conference, the National Law Seminar in Vegas this past week. Stephen presented on planning for the next stage of your career. And there's plenty to discuss there, but today we're going to keep to the topic. If you have any condo issues, if you're a board member, property manager, go to CAI. They have plenty of information. In fact, we are going to, at the end of this seminar today, because we can only fit so much into an hour, we are going to provide both a HUD guidance, which is a 19-page document, which was released in January 2020, as to, it's not the law, but it's a guidance as to how to handle animals in your communities. We are also going to provide a CAI best practices guide. Again, not the law, but some best practices you can follow when you are dealing with animals in your community. Not
And just so that everybody knows, CAI, the Community Associations Institute, is now an international nonprofit for the education, for the best guidance, for the development and operation of community associations, whether they be condominiums, homeowner associations, or co-ops. And we suggest that everybody should join this organization because you can get an awful lot of advice, articles, seminars at a very reasonable cost. Their Massachusetts number is 781-237-9020.
we can get that to them. And yes, very good resource.
Well, it's also the only organization solely devoted to this particular form of community living. So there's no other place where you can get it, centralized knowledge in one source shopping.
Absolutely. And they're national, international, actually. So anything you need, whether it's local, international, they are a huge organization. And yes, so now we'll get kind of to the today's topic. Look at this little cute dog. Not as cute as the two we have today with us.
Right.
But we are going to be navigating fair housing and the growing challenges of service animals, ESAs, and condominiums. Now, I was going to say, raise your hand. I was going to say, raise your hand. Yeah, you can raise your hand because I do think, yeah, I do think you have a function where you can do it. Raise your hand if you have dealt with pets in your community or service animals or ESAs in your community. Oh, we're getting a lot of hands raised. And I hope there's more hands raised for this. Raise your hand if you have a policy in place in your governing documents related to pets or animals. They'll probably be, if you're still rushing to raise your hand from the last question, we're getting a lot of them, so this is good. Both good answers. And if you haven't had an issue yet, you're most likely going to run into one, and that is where we bring in the expert Ellen Shapiro today to discuss what to do. Again, we will provide documents at the end of today's seminar that provide guidance, but we hope that we can be educational in our approach today. And let's move on to the next slide. So we're going to be discussing the two intertwined or kind of similar guide or acts, the Fair Housing Act and the Americans with Disabilities Act. They're both federal. The Fair Housing Act is an act that prohibits discrimination in housing on basis of race, color, religion, sex, national origin, familial status, and disability. There are local analogs, and we have listed the statutes that apply in each jurisdiction that we represent. You can, in Massachusetts, that's the one we'll probably be discussing the most today for ease of reference, 151B. And then there's other ones in New Hampshire, Maine, Rhode Island, and Florida. The ADA, which was passed around the same time as the FHA, which the FHA was passed in 1989. The ADA was passed in 1990, a federal law where disabled persons are allowed to have service animal. ADA does not apply to condos or housing providers unless the property is subject to public use. I did want to make a quick note because I don't think we discussed it in our presentation, but FHA defines handicap, whereas ADA defines disability, but they're almost verbatim the same use of the terms. So that kind of shows you how there's very similar interconnectivity between these two acts. But we'll get into the FHA mostly today. Again, those are just the definitions, which are pretty similar in nature, and provide what we are, the authority that we're relying on. And this differs from the Air Carrier Access Act, which prohibits commercial airlines from discriminating against passengers with disabilities. And in 2020, traveling by air with service animals allowed airlines to require passengers with service animals to provide airlines with two forms of documentation: the U.S. DOT service animal air transportation form, and the U.S. DOT service animal relief attestation form. So you can tell in that photo, Digby is traveling on the seat. So this must have been pre the 2020 kind of more stringent requirements. So just a distinction that we want to make before, because there is some, a lot of stuff we want to do today is debunk a lot of the kind of conceptions out there. There's been a lot of abuses in condos. There's been a lot of abuses in restaurants, in airplanes. I've seen, I think I saw in headlines like peacocks on airplanes. We've dealt with issues in condos with emotional support chickens. We'll get into unique animals. We'll get into all that today. So do you guys want to get into the reasonable modification and reasonable accommodations?
I think.
I do notice that there's a interesting question. And I don't know if Ellen wants to
I can't
start
see.
with that.
I'll read it.
Basically, we manage a property where dogs are not allowed. A group of tenants all went online, and all of them got doctor's notes from an online doctor in Virginia. All used the same site. The board are frustrated because it feels like people are abusing this, and they're wondering if there's anything they can do yet.
So believe it or not,
to vet these, no pun intended.
no pun intended. That's a good one. Believe it or not, there actually is, and we'll get into it in the webinar, there is an ESA watch list online, where basically you can, it's not foolproof, but you can verify if the purported vet is a medical provider is an actual legitimate provider. So we'll get into that.
Well, let me just follow up on that. The case that you're talking about with the Virginia doctor, he or she may actually be a licensed practicing physician in Virginia. And fortunately or unfortunately, in today's world of telehealth, it's not unknown for people to have doctors in other states or jurisdictions. And the law permits, and I use that word very loosely, people to find doctors in other jurisdictions who will help them with their particular issues. Now, I will say that when you have a group of people in one condominium with one doctor, and probably the provider letters are pretty similar, to me, that would be something that I would be interested in taking on. Now, let me start with what I always start with, but Stephen and Jake didn't give me a minute, so I'm jumping in now. I am a dog lover. I start all my meetings at condominiums and say, I will never live in a condominium. Why? I have a dog. I've always had a dog, and I know my dog is a barker. He is. And comes winter or a rainy day, I open my door and I say, go on out. Bye. See you later. I'll be waiting here with a towel. So I know that's against the rules. I will strike that. I don't know a condominium that would allow that. Maybe there's one out there, but I don't know it. So I want that freedom to have my dog and raise him as I see fit and stay inside when it's warm and not get wet. He can get wet, not me. So I will never live in a condominium because I respect the rules of the game. That brings us to the people who don't respect the rules of the game, which I believe you're having in your association. Look, we were talking about this before the seminar started, and I know we've gone a little afield here. These are tough cases, and we never know how a judge is going to rule. And if you wind up in front of a judge who maybe has 3 dogs, who knows, he or she could say to the clerk in advance, because this does happen. I'm sorry if there are any judges listening in. I want to rule in favor of these people. I don't want them to have to get rid of their dogs. Find a way to make it happen. So you always have to be sensitive to the fact that every case can be a loser. But if you want to do something with those people and with the Virginia doctor, I'd love to take on the case.
Absolutely. And Ellen, you brought up a good point, that, yeah, there is the guidance that we're going to provide is guidance. The law is very, loose right now and
Mhm.
very, kind of up and down.
It's amorphous.
Right.
It fits every circumstance depending on who's promoting it, which side of the versus you're on.
Absolutely. And that's what we'll get into the reasonable modification versus reasonable accommodation issue. And again, Ellen has dealt with a lot of these types of issues, not just as it relates to pets. It comes up with wheelchairs in communities. You need to build a ramp, different issues of that sort where disabilities or handicap, as it's defined by FHA, comes into play. Today, we're going to be discussing animals, and we're going to be discussing service animals versus support animals. Service animal is defined by ADA as any dog. Remember, specifically dog.
I think they also include miniature
That's,
horses.
I did, yeah, okay, I was about to ask that as well.
They include miniature horses.
Yes, so definitely, there is miniature horses or dog. So specifically, when you're looking at service animal, you're looking at dog or miniature horses. And it's a miniature horse or dog that is, it sounds silly, but we're gonna get to unique animals, so it kind of, that's an important distinction that Ellen has brought up. Any dog
Hey,
or,
Jay, can I go back to um a final point on Ellen's point about the condominium, no pets rule, 20 owners the next day, group up, they all got a letter from the same teledoctor in Virginia. The 2 points are, one is I would love to have, if Ellen takes on the case, I would love to have her depose the therapist. I also want to know.
I get, if I have to go to Virginia, hopefully springtime, I'll be happy to do it.
well, at this point, it's probably one of those just AI bots, so you'll be deposing
That's
a
true.
bot.
That's true.
And you have to play around with what's doctor-patient privilege, blah, blah, blah. But
We can take all that on. I'm not worried.
on some of these things, you get the impression, based on the amount of contact, that maybe they're scams, but there may be some very, very good online sources where they speak to the owner for an hour, 2 hours, give do a full intake and make the decision. The second thing I wanted to bring up was just that some states are playing around with language saying, if you're fraudulently issuing these certificates, that could be a penalty.
Yes.
And now I'll mute myself.
That'll be very nice when it happens, and we'll leave that for the next webinar on this after that's happened. Now, let me get back to what I believe I was supposed to be talking about, reasonable modifications versus accommodations. You can read the slides yourself.
Yeah, I was
You
about
don't
to
need
say.
me for that.
Right.
I'll tell you how I view it, which I think is very basic. Modification, you've got a policy in place. Typically, it's a restriction. Either no pets, no dogs over 15 pounds, or something of that nature. And that's what you are being asked to modify when you are confronted with a request for one of these animals. Now, we'll talk about this later, but when you're talking about a service animal, if it is a service animal for an open and obvious disability, in other words, if somebody's standing there with their guide dog and they are visually impaired, obviously, I think we can all come around to the fact that that's a service animal and the conversation stops. The reasonable modification is they want their dog there, no questions asked. However, when you get to, and this gets trickier, if the situation is not open and obvious? And I find that this is kind of an interesting area. What if the service animal has been trained to spot an epileptic seizure, post-traumatic stress disorder, the new issues that are coming up that we are aware of that are disabilities and that service animals are being trained to do? Diabetes is one of them, one of the more recent ones. In that circumstance, in that very limited circumstance, you may ask for a letter from the medical provider to establish the nexus between the disability and the service animal, whether it's a service animal or an emotional support animal in either event. But that's a very limited set of circumstances and facts. You can't go beyond it. Now, if it's been trained to perform tasks, you can ask what tasks it performs, because if I'm walking in with I think I look relatively healthy, and I'm walking in with my 17-pound Cavapoo, and he has a service vest on him, which again, we all know you can buy from the internet. And there I am, and I'm asking for this modification in your policy. You can ask, what is the disability? Not to get into the specifics, but something like, I have diabetes. The dog has been trained to spot when my sugar spikes. And the task is that it will wake me up. It will bark, it will paw, it will take all measures to get me up and out. So those are the limitations on that. And we come back to that when we talk about emotional support animals. The distinction, though, is whether it's open and obvious or not. Those are those three words, open and obvious. That's the hallmark. Now, when we get to reasonable accommodations, it's somewhat different, because you're typically talking about people who have, again, open and obvious crutches, cane, wheelchair, something of that nature. They are asking for accommodations in the physical, the modification. They're asking that the physical plant, if you will, be modified for their particular needs. Things like ramping stairs, things of that nature that they need to have done for them. That is very state specific. In Massachusetts, if it's more than 5 steps, you don't have to provide a ramp. And we're only talking about the common area here. You don't have to go into the unit and do anything. That's on the unit owner. But you do have to modify the common area if it's necessary. Swimming pools, by way of example, if it's a community swimming pool, you have to be able, the person needs to be able to get in and out to enjoy the swimming pool. And that's the other catchphrase, what is necessary for them to use and enjoy their housing as though they were not disabled. And that's very important, because we see things come up in that, do we have to provide somebody in sign language for the annual meeting? The answer to that is, in my opinion, yes, you do, because otherwise, how can they use and enjoy their participation in the annual meeting? I know a question has come up in the past. What about board meetings? That's a little different, in my opinion. I mean, the annual meeting is participatory. You could be voting on amendments. You could be voting on board members, things of that nature. Board meetings are where you are just an observer listening in. I can go either way on that. I tend to bend in favor of the handicapped person if it is a reasonable accommodation. Having a sign language interpreter, I do not think is a major imposition. Just remember, it's on the association's dime. You cannot ask that person to pay for their sign language interpreter. And that is extremely important. I've had cases where the board says to me, but they want to pay. They volunteered to pay. And you say, thank you very much. That's very nice. Nevertheless, you can't let them pay. And this is important. Now, having said all that, I would like to get to the, where are we next?
I'm skipping around a bit.
Yeah, you are.
Well, I just went to
Please do.
this, I went to this because and we will provide we don't want you to, be completely reading word for word on the PowerPoint, because we will be providing these after. We'll be providing some other documents. But essentially this slide that I have up right now provides, all right, it's true, pets are everywhere now. I know, especially when I'm in Florida, I lived in a high rise there, and it seemed like there were more pets than humans. It was quite the scene, and warm weather is just more pets and more pets out and about. Again, as Ellen just mentioned, how does a board member, property manager determine if the person needs a reasonable accommodation for a pet? And this gets into if it is, as the important words, apparent and obvious.
Open.
Open and obvious, sorry. If it is
Double
O and O, open and obvious. I knew it looked odd on there, but okay, open and obvious. And you're not allowed to ask the individual regarding the disability and cannot question it, but can ask about the need for accommodation in the assistant animal.
Now, one thing I'd like to point out, because we did talk about the ADA briefly, there is a common misperception that the ADA applies to condominiums and housing. And we get letters all the time quoting the ADA to us. It doesn't apply to housing. Where the ADA is important is that the laws, the local laws, your state laws, or your local agency that handles discrimination complaints, they will look to the ADA definitions as to what is a disability. So if the ADA has a definition that fits the person's mental or physical state, that will be considered a definition. So the ADA, we can't just say the ADA doesn't apply and then move on. We have to be cognizant of the conditions that they say constitute a disability. And for all intents and purposes, for anybody who's out there, who's a medical person listening in, they pretty much go along with the Statistical Diagnostic Manual. I think fifth edition is what they're looking at these days. So it's a very, very broad range, but nevertheless, they have to say to you, yes, this person is disabled under the terms of the ADA disability. They can't perform this major life activity, and this dog does that, helps them with it. To wit, it will wake them up if their diabetes plunges, if they're shaky, the dog will stand next to them if it's a larger dog and help them to be stable on their feet. There are many, many things that I think, unfortunately, people who are not dog lovers, and I know there's a whole world out there of people who aren't dog lovers, including our own beloved Ed Alcock. Nevertheless,
we'll still like them, even
Yeah.
though that's a red flag for
Yeah.
sure.
These dogs are very, very competent and capable of doing these things. So this is not a pitch for PETA. Let me make that clear. However, I do understand the problems. You move into, let's say, a high-rise condominium, you hate dogs, you're terrified of dogs, whatever, and suddenly you get into the elevator and there's this person with this terrifying James. And if you can't see him, he's very fierce, very fierce. But the person is shaking in their boots, literally. What do? That poor person moved here with an expectation that they would never have to see a dog in a closed box of the elevator. Unfortunately, the board has to yield in that circumstance if they've been provided with the proper evidence. They can't say, oh, we have a service elevator. James, you guys use the service elevator. You can't do that because the person who is disabled has the right to the same use and enjoyment as any other person, which means he or she doesn't have to use the service elevator. Now, these are all tough issues. I wish I could tell you the answer to all of them. They're case by case, they're fact specific, and they're costly to fight. And that's the rub for community associations. At the end of the day, it's how much money do you want to put into fighting this? Now, I'm going to skip a bit because you're going to get the slides later. What do you do with the person who says to you, I'm allergic to dogs? That's why I moved here. I'm allergic to dog dander or whatever. I have an allergy to this animal. Again, tough question. It's very easy for us to sit here on the panel and say, try to come up with a reasonable solution that works for both of them. I was at a seminar many years ago, put on, believe it or not, by the Mass Commission Against Discrimination. And I asked that question. Person is allergic. What do you do? And the answer I got was they can take a pill. The person with the disability has nothing else they can do other than have this animal. I have to tell you, I was stunned. I really was. I thought it was a somewhat cavalier and possibly irresponsible answer. I know as an attorney, I'm very hesitant to say to somebody, take a pill, because the next thing you know, they're allergic to the pill and it's my fault that they died. But having said that, this is the problem. It's a real one. We're confronted with it. And the reason I tell that particular annoying story is I don't think anybody has a good answer to that question. I really don't. So when we say try to find a solution, it's a problem that basically doesn't have a solution. And if you can get the people involved in the discussion, that's the best way. If you can get the person with the animal and the person with the allergy or the fear or what have you, if you can get them on the same page in a room to talk about it, okay, you need a HEPA filter so the person with the allergy doesn't sneeze through it. That's really the number one way to handle it. Because like
Ellen, if I could interrupt
No,
and
you can't.
ask you,
no,
ask
I'm on a
you,
roll.
She's on a roll.
ask you for an answer to this one. The MCAD said to the person that the person with the allergy should take a pill.
Could take a
Yeah, could take a pill.
difference.
Why couldn't the answer in some of these cases be that the unit owner or resident can take Prozac? Or who's to say that the only solution to the issue on a emotional support case is an animal versus a
Oh, that's an easy one.
medicine?
That's an easy one. The medical provider's letter says it. There's nothing else that works for my patient. He's been in therapy for 42 years. Great patient, comes regularly, pays regularly, but without the benefit of this animal, all the therapy in the world, all the medication in the world isn't going to work. That's what you get confronted with, Stephen.
And what if the resident goes to work each day? And this is my last question.
Oh, no, it's not.
No,
We
it's
know you
not.
better than that.
Goes to work each day for 12 hours without the animal, and
Weren't listening. I said that before. I said that even when when the other unit owners say, we see him walking out and going to work and doing whatever, and the dog stays here and he doesn't take the dog. That's not the issue. The issue is if the medical provider's letter says needs it to sleep, needs it to eat, needs it to take a shower, etc., and so forth, that trumps all. It does.
And back to the original point, and we did, it's right on point with a question we got from a participant prior to this seminar. What if people in my community each need a disability or modification and they conflict with each other? Our recommendation was find a solution that accommodates both parties as well as possible, while complying with the integrity of the governing documents and the policies in place. I do like Ellen's response though, which was okay, if someone just needs to take a pill versus a dog, the pill is kind of considered the less hindering to the community, as well as, and this is what we recommend for pretty much any disputes in an association, bring the parties together, see
Right.
if you can resolve it that way.
Now, you did touch on another point, I think, Stephen. What happens if you have two people with emotional support, because service animals are particularly trained. So I don't want to talk about competing service animals. In my opinion, a properly trained service animal doesn't bark or take on other dogs. But competing emotional support animals. What if my emotional support animal, and if my dog were, I mean, I happen to think all dogs are emotional support animals, but leaving aside my personal opinion, if your emotional support animal doesn't get along with somebody else's emotional support animal, Now that happens. It can happen. You have a wonderful dog, and for some reason, and anybody out there who knows dogs or has dogs knows that sometimes they get something in their head and they just don't like somebody or another dog. What do you do under that competing circumstance? That's a tricky one. Again, I would suggest have the two dog owners sit down and see if they can hash it out. My dog has to be walked between 6 and 6:30 at night. My dog, I can have my dog go from 6:30 to 7. It all depends on the reasonableness, not only of the accommodation being asked for, but the people asking for it. And unfortunately, and this is, I have no empirical evidence, this is anecdotal, the people who I think are gaming the system, let's say with the phony letters or what have you, I think they are the less reasonable ones when confronted with your dog is creating a problem for another owner. That's just anecdotal, but it kind of goes along with the mentality that games the system.
And with Jake, we used to have him do play dates if there were issues with humans. Would that work for dogs?
Not
Next-
going.
I'm not gonna ignore that part.
Next slide, I'm muting myself.
I wish
You're muted.
I need the mute button that they have
Yeah.
on around the horn.
Okay,
So what can you do as it relates to unit owners taking advantage of support animals? And we kind of have been getting into this a little bit. And yes, we are mostly discussing support animals. The service animal bar it is and it only relates to dogs, only relates to mini horses. There needs to be a specific purpose that, and again, as the keywords, open and obvious,
and training.
and training.
And training.
So, but support animals is what we're mostly discussing today, and that is the, wrinkle that has, or area that has become a lot more conflated with
And contentious.
and contentious. And so someone asked, that everyone has anxiety, depression. Everyone can get a pet, and a pet, the bar used to be, okay, a support animal improves your anxiety, depression by some, it can be a little or a lot, whatever, but there's no way of judging that. There are ways to look into the verifiability of the ESA letter. There is an ESA watch list that looks into sources of the letter and reliability. Some states allow, or I should say that condos and HOAs have the right to ask for proof reasonably. Cannot allow the animals to disrupt the community activities. And there are other measures that can be put into place for taking advantage. We will get to the unique animals, which is another,
Whole other.
that's a whole nother area, because that kind of, yeah, subspecies, literally. But takeaways so far, yeah, there's misconceptions by public and misuse of terms. We have kind of been getting into the service animals versus support animals. Federal law, you want to look at that, the ADA, FHA, I should say. And then there are also local and state analogs. Those will govern what you're doing, or should govern what you're doing as your policies in place.
I just want to jump in with one more thing, because it's easy to cut off Jake and Stephen.
Yeah.
There is no registry for emotional support animals. That's another one that's out there. I've even seen it on Facebook, the pop-up ads. Do you want to take your dog with you everywhere? You can get a registry certificate for it. There is no such thing. Absolutely, it is not recognized. See? I don't know if you heard Dig, but Digby just concurred. And that's one that we hear all the time. And they come up with this beautiful piece of paper. It's got a seal on it. It's lovely. No.
And
you don't have to accept it.
yes.
So somebody asked whether, and it's probably me, whether I'm not asking the question, but mixing requirements for emotional support animals versus service animals. They say, my understanding is the comfort dog does not always accompany the owner, whereas the service animal does.
Yes, the answer is yes.
Yes.
The comfort animal works. And I somehow I dislike the use of the word comfort animal. I really do. It's an emotional support animal. And
Yeah, that confuses it a little
Yeah,
bit more. Yeah.
right. And the emotional support aspect is when I'm at work, I'm fine. I'm busy, I'm engaged, there are people around, but when I go into my unit at night, I'm alone, I get depressed, I can't sleep, I can't eat. That's why I need it in my unit, but not at work.
And Ed says he has his emotional support whiskey instead of emotional support animal.
As you can see, he's sorry he wasn't here today, but he's here in spirit, literally spirits.
Yeah. So I did want to get to the point that again, we emphasize getting a policy in place if you don't already at your association. And the laws regarding service animals will override any condo governing documents restrictions on pets animals.
And basically, at the end of the day, properly qualified emotional support animals will override them too. And I know people, real boards struggle with it, other owners and occupants. Oh, occupants, let's talk about that for a second. My unit owner in a condominium or that allows rentals. My tenant needs an emotional support animal. What do you do about that? My opinion, again, you have to do it because that is allowing that investor owner to use and enjoy his unit like a person, any other person. And you can't discriminate against a person with disability in leasing. So there you go.
So we want to get, and then the next one we want to get to is, and again, yes, continue asking questions in the chat. I do see some are coming in, but if we don't get to it during this presentation, because we wanted, this one's mainly to get on the key points educational, but if there are specific questions, we will address those in a Q&A response via an email blast next week. I wanted to get to unique animals or non-traditional animals. And we got a question from a participant that directly related to this. What should I do as it relates to non-traditional or unique animals? This could include emotional support chickens. We have dealt with that in the community. Peacocks, turkey, and I mentioned the peacocks that were on the airplane before. That just seems dangerous.
That was the United Airlines case.
Yeah, and so that, I mean, it's happening, and
It happened. It's not happening anymore.
Hopefully not.
No, the airline act.
Oh, airlines
Right,
done, but
right.
as far as associations
Oh,
go,
associations are different, right?
yeah, you could still see. I mean, we saw a chicken, yeah, a couple months ago. And the key here, some governing documents include this, but the owner requesting the unique animal has the substantial burden of demonstrating a disability-related therapeutic need for the specific animal at the development. The requesting owner should be able to document and demonstrate the circumstances justifying the need for a unique animal versus a dog or a miniature horse. So this is purely emotional support animal. Unique animals do not even tie into service animals,
Right.
because the service animal is
It's only.
dog and miniature
Right,
horse, which is,
right.
I guess you could define unique, but the other non-unique,
Right.
non-traditional unique ones. So I want to just touch on that briefly. It could be important to add something as to a clause in your governing documents or rules related to unique animals, because that is something we've been seeing in our communities. Again, we're going to provide the HUD guidance that was released for the FHA in January 2020. Do you guys want to touch on that at all, or?
Well, it's basically, I think we have paraphrased all of it. The important point is that HUD is operating under the purview of the Department of Justice, which, you know, that is very important. Their ability to sanction comes out of that. Not that they're going to be indicted. I don't want to have anyone to think that the, you know, state police or the militia are going to be at your door, but it shows the importance that has been placed on these issues. You really should you really have to be careful in doing this. You just have to. And I think that's the watchword. You can't do a knee-jerk analysis, and we're going to be sending you all this stuff. So as I said, I don't want to, you know, just read it to you, but you have to be careful of the knee-jerk reaction. Person moved in here, they knew we didn't have a dog, no pets were allowed, and now is saying he or she needs it. That just, you can't do that. I mean, that's a simple statement. You can't do it. And I've heard all the grumbles. It's not fair. What is the government doing, telling me what I can do with my property? It's a private community. That's a big one. We know that. And basically, we agree with you because we're land use attorneys. But this is an area that the government has said, we are going to come in and do some legislation, if you will, that takes away from your right to self-governance.
I think, yeah, and yeah, the HUD guidelines, we have paraphrased a lot of that today. We're trying to get the 10,000-foot view. It's a 19-page document. We will send it after.
And it's fascinating reading.
It is, yeah, it's great. It'll put you
to sleep.
Yeah, it'll put you to sleep, hopefully with your emotional support animal right by your side. And yeah, I let my dogs in the bed. I know a lot of people.
Oh, I do.
Yeah, a lot of
Yeah.
people are strict about
Yeah.
that. Like my dad, he'll be like, "Get out." No, I'm kidding. He lets them in too. But I wanted to touch on some of the guidelines. Very important note before I get into it: the HUD guidelines are not mandatory law, but are highly recommended as they provide best practices. We also want to give that quick plug to CAI, which also provides the best practices. I think it might be a little shorter than the 19-page that
It's an easier read.
easier read. It's usually, they do 1-page kind of best practices. What I did want to point out, step by step set of best practices and a process that you should have or could have, and again, guidance in place for the compliance with the FHA. It has the info on the types of animals. Again, the distinctions between a dog, miniature horse, and a peacock or turkey, and best practices when the animal is unique. Determining the reliability of the documentation, which we got into a bit today. Yeah, if you're getting the same letter from the same from 10 unit owners about the same doctor, that's
a red
sounds,
flag.
it's a little fishy. They should just emotional support
About
fish would
fish,
be better.
right.
Yeah, a fish that would.
I knew that's where you were going.
Yes, exactly. Yeah. So a fish that would get in no one's way. That probably wouldn't be restricted.
Well, there's high-rise condos don't like big aquariums.
That's true,
because of the
too.
water, if they leak, you can have a real water problem.
Mhm.
So everything that you can think of, a unit owner will beat you
Yeah,
to it.
and that's a great point. Because every issue should be dealt with on a case-by-case basis, and that's kind of how HUD provides for. It encourages the condo and HOA to engage in a interactive process.
That's really the name of the game.
Yeah,
the
interactive.
Right.
And if it's, yeah, again, the competing unit owners,
Mhm.
get them together, get them in a room. I don't know if you should bring the pets there because that might cause some issues. But don't be overzealous or overreaching in requesting details, but actually interact. Oh, and also an important note, the information may be confidential, so you need to be very careful with that information as well.
Good point, Chip. I will get questions from boards. Well, what do we do when unit owners want to know why this person has a dog when we have no dogs? What should we say? And the answer is we comply with the applicable laws governing this dogs.
Perfect.
And if people are so stupid that they can't read between the lines on that, that's their problem. But at least you are not violating anyone's privacy.
Okay, and that's a great point, and it brings us to kind of what happens after maybe privacy is considered breached, or there's an issue with the unit owner. Again, these are unclear laws. A lot of this is arising out of unclear laws, so it is completely ripe for discrimination lawsuits, complaints, what have you. And that discrimination process is a whole nother complaint process. It's not just a lawsuit that's filed. What would you expect in the event that a unit owner does complain? Complaint is usually mailed to HUD, Housing and Urban Development, or Fair Housing, and potentially the Equal Opportunity Commission, the EEOC. Often in the form of a discrimination complaint. Again, completely arises out of unclear laws and circumstances. So just be very careful with how you're intaking every single kind of process, right, Digby? And but the complaint process itself, there will be an intake. There will be an investigation. Sometimes the buck stop there. Sometimes it's a little more involved. And then there is a period, you probably know this better than I, as far as Massachusetts, there's a period after.
When it goes to the hearing officer and it gets reviewed, et cetera, and so investigating officer and all that. Don't worry so much about that, because what I'm going to say to you, and it's not self-serving,
legal
you
counsel.
get that document, you pick up the phone and call your attorney. Let them worry about the time periods involved. These are strict time periods, and anybody who's done any work in this field will tell you that, particularly in Massachusetts, where we deal with the Mass Commission Against Discrimination, which is, I say, exists to find discrimination, because if they didn't find it, they'd be out of jobs. Nevertheless, they are unyielding to attorneys asking for extensions of time or things of that nature. But when it comes to the complaining person who feels they've been the subject of discrimination, they can have all the time in the world. They don't have to follow the rules. So really, really, really make sure you get your attorney involved in the first instance.
Absolutely.
And I'll tell you what also happens. This is an aside. The unit owner has no idea what they're doing. So they say, and managers, I know you've all heard this, management has discriminated against me, as though the manager just decided not to allow a dog. I mean, so it's very broad. The ability to make a complaint is so easy, so easy. And don't forget, they're also getting, and this is a practice point, they're getting free advice. You go to the MCAD or any of these governmental agencies, you get free lawyers, free hearings officers, free investigators. So it's very, very easy for them to do, and it's a real hard burden for the association. It's one of those cases, even if you win, you lose, because you had to pay your lawyer to do all this work. Again, you get a letter, you immediately pick up the phone.
Yeah, and I would say even, yeah, as soon as you even smell the possibility of an emotional support animal being involved or some type of complaint being made, it's usually the people who are going to abuse the system that will complain as high as they can.
Right.
They're going to push their luck. So the second something happens, consult with counsel. And they will be able to guide as to, making sure that you, and we'll get to some takeaway. I think we'll be able to get to some other questions too, because we have some time. Make sure that you're incorporating your policies and governing documents and procedures correctly. Enforce with consistency. Don't be selective, because that just is gonna, that is most likely gonna lead to issues. You want to investigate on a case-by-case basis. Treat all requests equally.
And that's a fundamental tenet of community association law, as we know.
Don't be selective.
Jake, can I add?
Nope.
No,
No, I think the people listening will.
Okay, go ahead.
Will like this.
Yeah.
Ellen has talked about these cases being very expensive, that in many cases, a lot of it is free for the owner of the pet, of the animal, I'm sorry. The insurance, now I know there's an insurance crisis and skyrocketing premiums and all that, but there are some very good directors and officers liability policies
that will provide a defense.
that will provide a defense. What does that mean? That means that typically you could ask them to appoint us or your own lawyer, but they would, subject to your deductible, which is typically pretty small, say $1,000, they will pay for the defense. But once you get that first letter that Jake was talking about, once you smell trouble, put the carrier on notice. There's a very good policy written out of Los Angeles by Kevin Davis Insurance Services, and there are other good policies with McGowan in Ohio, Wayne Dow at Preferred.
Well, friends you saw last week, so he's trying to talk. He's trying to
say that again.
These are all your friends you saw last week at CAI National.
Say that again.
Never mind.
Never mind.
Okay. Okay. Yeah, all the friends that I saw at I taught at the CAI law seminar in Las Vegas last week, but there is make sure you have a very good condominium insurance agent, and make sure that you have the best advice in terms of, well, gee, we have employees. Does the D&O policy cover this? Some do, some don't. Some cover discrimination, some don't. Typically, it wouldn't pay a judgment in these cases, but if there were a settlement, oftentimes they would. So
Yeah, and I think that's a good takeaway in general. We're only lowly attorneys. We can only offer so much. Get the right insurance agents in place, if it's and again, we're getting off topic a little bit, but if you have structural issues, whatever, engineers. But let's get back to, yeah, just make sure you get the right people, get the insurance agents, make sure those are okay, D&O, all that. And yeah, just the last point as to final takeaways, keep the records confidential, and be uniform in your application. We are getting some questions, and actually we just got speaking of insurance, does the tenant who has the emotional animal required to have insurance to cover the animal, or does the association policy have to convert the animal? Example, a dangerous pit bull.
Well,
no, the insurance is for the unit owner can go to the Mass Commission Against Discrimination. What I was talking about was the condominium association board and manager should look for a directors and officers monolined standalone policy, usually, that will defend against discrimination claims. Ellen, do you see? I mean, tenants should get insurance if
I think that goes back to whether or not in your governing documents to begin with, you have a requirement that if a unit is going to be rented out, that there has to be renter's insurance. So that goes into a whole other issue of what do you do with tenants to begin with, and how do you write your documents? I do not think that it would be considered reasonable to require a tenant who is disabled to have insurance on that animal.
Mhm.
I really think that'd be reasonable.
I would agree, and the unit owner has to thank. Let's say it's a pit bull. My understanding is there's a case out of New Jersey that says that you can't discriminate based on a breed. So
Right.
therefore, you have to get to know the specific pit bull and see if it's friendly or if it goes after you. And after you interview the pit bull, then you could allow it. A question for Ellen I would have is, well, for that question is, you may want to have insurance, though the insurance company may not give you coverage for the animal's behavior. But what if an animal, God forbid, does bite somebody? And I guess my question for Ellen is, would the MCAD or HUD ever allow a policy that says, well, you can have the pit bull, but it has to be muzzled when in the common areas?
I wanted to bring up one.
Not from the get-go, not from the get-go, from day one.
So
No.
after the first bite?
If there were some series of problems with the dog, if there were complaints, I think that prior to taking a position, okay, the dog has bitten people, we want the dog out, we don't care, that would be the next interactive dialogue. When the dog is out on the common area, you can put a basket muzzle on. There are muzzles there are many muzzles, not like Hannibal Lecter muzzles, but there are compassionate muzzles where the dog can't bite. So I think that would be part of the interactive dialogue with that owner. What do you do when the owner is allowed to have the animal's causing problems? Let's be clear here, folks. If this is a vicious animal, I don't care what the MCAD HUD, I don't care if the governor says to you, this person needs this dog. You do not have to allow the dog to be a problem in the community. And even the HUD guidelines say you do not, and I'm not talking dangerous breeds because Stephen's right. You can't say no Rottweilers, it's a dangerous breed. But if you can have a poodle that goes around biting people, and if that dog is biting people, that's a problem, and you have a right to go to the next step, which is the interactive dialogue, see if you can find something. And if the owner refuses to cooperate, I would say that you can then take the position that the dog has to either remain in the unit or not be maintained anywhere in the condominium. Because
And I saw a question come up that,
you don't have to have the community endangered by this dog.
yeah.
What about the emotional support alligator? You know,
And chihuahuas can be nasty and
oh yeah,
yippee and
ankle,
all that.
the little dogs are called ankle biters for a reason.
But I saw a question that I think needs clarification, at least for Massachusetts. Somebody said, what if there's a rule that says you can't have pets and people bring in pets? Stop right there in Massachusetts. Going back to the case of Johnson versus Keith in 1975 or so, the either appeals court or Supreme Judicial Court ruled that Mrs. Johnson could have her poodle of poodles, and it couldn't be in the rules that it has to be in Massachusetts in the master deed, or at least in the bylaws, declaration of trust. So check with your attorneys in all these cases, check with somebody who knows the state law in each state to see whether a rule would be allowed. But Ellen, you agree that a pet restriction would be not allowed as a rule in Massachusetts?
Oh, absolutely, but that's like for a whole other issue. Having said that, if you have a no pet community which did not have any pet rules, which is a different thing than having a rule saying no pets, but pet rules, how they can be walked, et cetera, and so forth. You can implement rules for this particular set of circumstances. If you are going to be confronted with people who need pets for what dogs or miniature horses for whatever reason, although I've yet to have a community with a miniature horse, maybe out in Western Mass it happens, that you can have reasonable rules, that the dog must be on a leash the second you step into common area. That is a very benign rule. That must be on a handheld leash secured.
Well, try it with a miniature horse.
Miniature horse, yeah, that's the right goal.
Well, a lead,
So
bridle and lead.
that actually we got,
We're past the hour,
Yeah,
but
so-
we always are because I talk too much.
Yeah.
Anybody who wants to stay on for another 10 minutes, feel free to.
and I did want to point out, I did post the HUD guidance link as well as CAI best practices and basically a recommendation that CAI provides. Read those at your leisure. Those provide plenty of sleeping material. And I did want to point out a question actually that relates to what Ellen was just talking about with the leashes. Can you require support animals to comply with the same rules that a regular pet is required to follow? For example, dogs must be on a leash at all times while on
Yes.
condo property.
Yes.
And the answer is yes. Another question we got, if an owner wants to rent to a person with an ESA and the rules state the board needs to review, could they drag out the review process? Could the board drag out the review process past a proposed lease start date? And
No,
no.
There I have a problem in Massachusetts. If it's a rule, it really should be for them.
let's assume everything's perfect in their documents, because that takes us down another rabbit hole. So let's
Okay.
everything's perfect in their documents and everything's in the right place. But the answer is no, they can't drag the process out. The answers to any inquiries about whether or not they can have this animal have to be given in a timely fashion. And that's important. I had a case where the board, we'll do it at the next board meeting. We didn't have time at this board meeting, and it dragged on, and the unit owner's attorney, rightfully so, said, hey, you're violating the HUD regulations on this. It has to be timely, and that's not timely. And we eventually got it done, but the unit owner's attorney really was correct.
And another question, this is a good one. An issue has
They all were good.
Yeah, well, of course, but this one stuck out to me. Oh, well, of course, they're all good. I think they're all great, all great. But this one I wanted to point out because we didn't really get to it. A question has come up with a resident tenant claiming they need multiple ESAs within a single unit. Is there anything associations can do to limit the number of animals?
That's a fabulous question.
See,
and
I knew it.
Actually, before the webinar started, we were talking amongst ourselves about that particular, well, not that, but touched on that issue. I think that, again, it's going to depend on the level of evidence presented to you. I don't want to say proof, but evidence as to the whys, the nexus, and all of that. The particular disabilities. I think it's going to be on a case-by-case basis. I can't give you a blanket yes, no, maybe so. Well, I guess maybe so is the answer I'm given. Again, it's very fact-specific.
I am aware, but not in another state, but not enough to know what the ruling was. But it might have been against the owner, but the request was for 6 chickens, not 5, not 7, 6. I think the court might have rejected that, but again, talk to Ellen or talk to your legal counsel, because these cases has been said time and again that are very fact specific.
Well, they also, don't forget the chicken cases, they also had to deal with municipal bylaws about whether or not you were in the business of raising a chicken, how many chickens you could have. You know, you've got those issues as well. So
where towns don't allow fowl.
Right. Or they allow 2 chickens or what have you. So it's a very big issue, but you know, the issue, where we started with the question, I did have one many years ago where a person had a care provider, it tied in with housing for older people and all that. I mean, we really got down the rabbit hole. The care provider had an emotional support animal. Needless to say, the board said, wait a minute, you're providing care, but you need care too?
It's gonna be like Noah's Ark. You're gonna be
Right,
bringing the one
exactly.
pet to the next one.
Exactly. But at the end of the day, in the final analysis, the answer was yes. The person needed an emotional support animal to help them sleep, didn't interfere with their duties as a care provider, showering, giving medication, feeding, you know, preparing meals for the disabled person. So it's just a plethora of legal issues, and this isn't self-serving. That's why you have to call your attorney.
The other thing to do, putting aside the screen, where somebody from Peter will probably get angry with, well, we'll blame it on Dina. For the was a little depressed today, so I decided to get me one of those emotional support animals. What's that?
I sent it to her, I said, you've got to get it in there.
It's a, yeah.
Okay, so if you have problems with that, talk to Ellen.
Right.
But what I was gonna say is, with all we've said, we focused a lot on the negative. Go open your minds to the idea that there are some people, think of your mothers or your grandmothers or grandfathers, who, especially if they're widowed, who may haven't truly have a need for an emotional support animal. Don't just assume out of the chute that everybody requesting one is scamming the association. Don't take the position that our documents are the Bible. What does HUD and MCAD have to do with allowing pets? Don't overlook, by being overzealous, the cases where, for example, the blind person who needs a seeing eye dog is easy, but these emotional support animals don't start with, oh, it's just another person scamming us. There are some, I mean, Ellen said she won't live in a condominium because she needs her pet. It's not to be taken lightly. So Ellen, can you say that better than I did? I'm sure
Probably.
anybody can, but
Probably less words too. No,
oh, definitely in less words.
I,
But there are some cases that aren't
Yeah.
scams.
You can't even, that was less
Yeah.
words.
I'll see you at lunch, Stephen.
One more question. A dog, all right, this is kind of just relates to pets generally. How do you handle a unit owner with a black lab, home alone all day, barks and whines continuously, disturbing other units? That one is essentially, I mean, it becomes quiet enjoyment and
Right.
noise
Again,
issues.
You're interfering, but we said the animal cannot interfere with the, if you will, business of or the living circumstances of everybody else. And that's a tough one. But, and I don't care if it's a black lab, my 17-pound Cavapoo barks and he drives me crazy if I were in a condo, let alone other people. It's a problem, and I take the position again, and sound like a broken record, talk to the owner, make sure the owner understands the problem. Maybe even get some other owners to come into a meeting. They may not want to confront the owner face to face, but come into an open meeting with the board and all that to discuss the problems and what can be done. I know I leave the TV on for my dog, and when I get home, he tells me all the day's news, but he might have to, and I hesitate because the next question will be who pays for it. But it might be necessary to have somebody come in during the day to give the dog a break, to play for a little bit of time so that he can get past the loneliness. I don't want to get into who's going to pay for it right now, because that would be a whole other webinar. But there are things that can be done other than the knee-jerk reaction. Your dog is interfering with everybody else. We gave you the dog, you needed it, but you can't do it. Even HUD says you can't disturb the whole community. Don't go right from 0 to 100. There are incremental steps to take.
Mhm.
Ellen, how can
Another
people?
unit owner there who wants to go in and play with the dog and is happy that there's a dog in the area that he can play with. You know, there are many different ways. You have to think outside of the box.
Ellen, you've been wonderful. How can people? But it's 12 past the hour.
Let's do one.
How can people reach you? And
Oh, I was gonna
obviously
get
they
to-
can.
Okay, smoke signal works really, really well. But, oh, look at that. We have a slide with the
We have a
information.
slide with our information. We thank you. Well, okay, what, if we can do this quickly, because it's relates to the question that was the good one. If there's one unit that has multiple ESA requests, so let's say there's roommates, how would you go about handling that? Let's say there's 4 roommates in a apartment, 4 ESAs.
Again, case by case basis. And what are the ESAs? Are they each 200-pound German Shepherds? Are they like, look at President Biden's dog? You know, if he needs it for an emotional support animal, he's got a problem with the Secret Service. They're really unhappy with him. You know, you're going to have a case and you know where you could see that actually gets back to the old City of Oxford case, Stephen. What if it's a group home? And there are many residents in there who do need emotional support animals, and that's a good point.
Yeah, that's Edmund, Oxford House, Edmonds versus
Right.
City of Edmonds versus Oxford House.
Right.
Is a Supreme Court decision, I believe, but very, very powerful.
About
And Ellen's absolutely right. If there's a group home,
probably, let's say a group buys a unit or two as housing for their people who they provide services for, and 2 or 3 of them need emotional support animals. I have a really, really, really deep-seated feeling that you would have to bend on that and allow them all. I just feel pretty strongly, because you can't discriminate against the group facility. You have to allow that. And then you can't have the people in the group being deprived of their right to use and occupy and enjoy by not having their emotional support animal. So I think it's a great question. I hope it doesn't come up tomorrow when my phone rings, because I'll probably live to regret this. but I have a strong feeling that the association would lose if they try to prevent it.
So that's a great closing
way to end,
remark,
yeah.
and case by case, do what you can. It's not a blanket solution, and that's why this wasn't there was no way we were going to finish all that we could get to in an hour. Again, read the HUD guidelines, make sure you have policies in place, and kind of look at all of that. We have left our information here. If you have questions for us, we are all at the AM Condo Law website, or I should say email address. And you just get our first names: Stephen Marcus, Jake Marcus, and our special guest, Ellen Shapiro. And special guest as well, who didn't really talk much today. Digby was a little whiny at
He
points.
was whining when Stephen was talking.
Yeah, exactly. And they say thank you. They're very proud guests today and glad that you came along. And
Examples of well-behaved.
yes, the best comment I think we got today, or best question, comment, what have you, is Digby is quite a good dog. So what do you think of that, buddy?
But we have them on Prozac. So Jake, you're gonna be sending people the PowerPoint?
Yes, and the HUD guidelines.
And the HUD guidelines, and then next week we'll send answers to all the questions that were asked.
Correct.
Mhm.
And we'll send them to everybody who registered, not just those who attended.
Yes, for sure.
And I know a lot of you have dropped off. You know how to reach us, other than I'm skeptical of Digby's email address. But you know how to reach the rest of us. And if you have follow-up questions.
Oh, I'm allergic to the dog.
Perfect. Right at the end.
Right at
You
the
held
end.
it in for as long as you could.
I'll take a pill.
Perfect. Can't leave Digby. All right, but we do appreciate it. We will have the materials. And thank you for attending. Have a great
You've been
weekend.
a great audience.
Yes, almost as behaved as Digby. All right, thanks everyone. Stephen, we'll see you at lunch. Stephen, one
Yep.
time. Quiet. Wait till the end.
Yeah. Now Jake and I have to brush ourselves off.
Yeah,
We're
for real.
covered.
Yeah, yeah, we still have some attendees.
You will get a recording as well.
Yeah.
Any questions that are popping up here that we don't get to, again, that will be in the last afterwards,
Mhm.
the follow-up. You will not be ignored.
Thank you, Ellen. You did
The 2.5 minutes,
beyond wonderful.
the 2.5 minutes you let me speak? Oh, good thing I love you, Stephen. Good thing.
Love is all you need.
That's right.
Okay, see you at lunch.
See you at lunch.
Bye.
Bye-bye.
Bye now.